So then this is just a really quick, I mean, there's a lot of research covered. What we try to do is have as comprehensive a review of the research that was conducted in this area in the year, and try to summarize the findings so that people can have an overview of what was done in the year. And this is me pulling out just a few of them because there was a lot of really good work done last year, and I just tried to pull out some highlights. So highlights, of course, that seem to have included our own work. So the first one that we want to mention is in international protection, and it was this explaining the 2022 increase in international protection applications, where we looked, and I mean, this was an ESRI piece of research led by Emily Cunniff, who is joining us today and will be presenting shortly. And kind of looking at data and the literature on this in other contexts to try to come up with explanations. And I discussed that already, but you can see them there, the post-COVID-19 catch-up, kind of global instability and conditions in countries of origin, UK policy changes and a deflection effect from that, as well as secondary movements of beneficiaries, which there's very little research on, and a long-term network effect, as well as a generally positive perception of Ireland. We found that reception policies don't seem to play a role in this type of asylum, but a generally positive perception of a country as a safe and stable place to live does. So then the other really interesting piece in this was a NASC paper on, so NASC and NGO down in Cork, on the implementation of the white paper based on freedom of information requests and qualitative research. And they made issues and recommendations in a range of areas. It was really interesting, I think, exercise. So they flagged some things like the need for multi-year capital expenditure budgets for delivering on accommodation commitments and some delays that had happened there, and the need for a clear policy of dispersal between different counties and areas, potential over-reliance on approved housing bodies in the white paper, and the fact that the daily expense allowance hasn't been reviewed since 2019. That's kind of me pulling some things out, but there's a huge amount of content, so I really recommend that report. NASC also did another really interesting report on international protection on equality issues and community sponsorship and experiences that people have had. And a huge amount covered there as well, and generally kind of, I think, quite a positive report, but also concerns raised about disparities with the mainstream resettlement program and supports provided, and some spatial inequalities in public services and challenges as a result, and the need for oversight of community sponsorship groups and a formal complaint mechanism for refugees who had been resettled through community sponsorship. But another really, really great piece of research. On temporary protection, then, we saw the Ukraine Civil Society Forum publish a briefing paper, which I think is really interesting, and really had a broad range of recommendations about the response. They did raise the concern that had been raised before about inconsistency with international protection applicants and supports provided between the two groups, and had a range of quite strong recommendations on governance. So the appointment of a national refugee response lead, and a national coordination group, a director of service on this for each county, a published plan with the state's approach for transparency, the mandating of the housing agency for medium and long-term accommodation, establishing a refugee agency, and resourcing welfare and integration. Again, that's just pulling out a few, a lot of content in that report. In unaccompanied minors and vulnerable groups, we saw this ESRI report on migrant origin children's development, and it showed that kind of the real factor that matters for vocabulary scores in particular is having two parents that are non-native English speakers, with lower reading scores still at age 9. And they did find that wellbeing scores don't seem to differ, although there was some kind of group-based discrepancies, but a really interesting report there too. Citizens Information also published a report on the information needs of vulnerable migrants, kind of assessing their own capacity to meet those needs, but also making recommendations for how they could further improve that, which you can see there. And they also made recommendations about actually reducing the number of vulnerable migrants and the vulnerabilities of this population. So regularization was one of them, the regulation of private rental housing, the migrant integration strategy update, and streamlining registration processes so that less would be put on that group. Integration is always an area where there's a lot of research, and we again saw some really interesting stuff here. the Immigrant Council of Ireland did a really interesting survey of local authorities to come up with indicators of local integration actions to see how well they are actually applying the integration strategy and mainstreaming this in their approach. They found progress in programming and services, but less in kind of updating internal structures. Really interesting report as well. Matthew Creighton and some others published in a journal, Mass and Unmass Attitudes Towards Migrants, which is a really interesting list experiment looking at attitudes, and found that support for certain groups, so Black and Polish migrants, is overstated when asked directly, but attitudes to Muslims was not sensitive to anonymity, kind of indicating that it's more socially acceptable to have more negative attitudes towards Muslims than other groups. I can explain that a little bit more if anyone would like. EMN Ireland, then the ESRI published the integration of non-EU migrant women, which looks at policies and practices in Ireland and looks at this double disadvantage that migrant women face over a variety of areas. And the ESRI also published a great piece on which looked at 2016 census data on housing and family among migrants. I've just included housing here, but there's some really interesting family data in there too. And again, we see, migrants are more likely to live in private rented housing, in overcrowded accommodation, and they're much less likely to be owner occupied. But the really important thing is actually the duration of residence, but it also varies greatly across migrant groups. And of course, there's an overrepresentation in homelessness figures compared with the proportion of the population. And then the last one, I think there's two more, trafficking. So EMN Ireland and the ESRI published trafficking policy and practice in Ireland. That is, again, my colleague Emily Cunniff is here with us today on the policies and practice in Ireland around detection and governance structures, and some concerns that were raised. And then again, EMN Ireland and the ESRI published a brilliant piece, and that was my colleague Emma Quinn and Michal, I believe, on responses to irregularly staying migrants, and how kind of policies, practices, and how the situation is regulated in Ireland for those who are staying irregularly. So we're going to combine the questions and answers for this section with the case law section. So I'm going to pass straight over to my colleague Emily for that now.
Thank you, Ciara. You're all going to have to bear with my slightly lost voice. Okay, so the next slide, if possible. So I'm just going to go over some of the key cases from 2022 related to asylum and migration. And these are all the ones that are summarized on the website. There are, of course, a lot more cases from the courts in that year, but these are the main ones that we have available online. Of course, if there's any case that you think should be there that isn't there, please do let us know. We're more than happy to have a look. So the cases for 2022 fit into kind of 5 different thematic areas. And the first one was immigration permissions and leave to land. So one here was Rahman v. Healy, and that concerned a taxi driver and his application for a taxi driving license when he held temporary immigration permissions. So that's a very interesting case in terms of good character requirements, but how it exists outside of the immigration system, but how immigration can impact on that. Akram was a case on a refusal of leave to land at Dublin Airport, and whether a border management unit officer can look at somebody's phone and retain information from that phone in deciding whether to refuse someone leave to land. The second category was then international protection. So MY was a case on an international protection applicant who might re-engage in activism upon return, and what that meant for refoulement considerations. A and B, and I'll go into a bit more detail on A and B in a minute, but that's about timelines for appeal and the definition of applicant. And then ASA, which was a Supreme Court case on the conflict of roles or functions between somebody who is a decision maker on an international protection application versus a person making a decision on leave to remain. And then 2 key cases on citizenship. UM is another one I'll go into more detail on, about derivative rights for a child. And then AJA is about a Somali national applying for citizenship with a false passport who had stated it may be false in her application, and kind of the assessment of that case by the minister. And then fourthly, family reunification. So these 2 related to Section 56 of the International Protection Act. So that's for refugees or beneficiaries of international protection, rather, who can apply for their family members in their home countries. And SH and AH concerned 2 people who had applied for international protection, but during that process, some of their children had turned 18 at home, And that case considered whether or not they could be included within the Section 56 provisions. It was found that they could not be. HA is an aunt who applied for her niece and nephew in Somalia, and kind of the definition of adoption and family unification. And then lastly, deportation. And this is another one I'll talk about in a bit more detail, which is MK Albania. So Article 8 of the European Convention on Human Rights, and those provisions there. I better keep an eye on time. Next one. So UM was a case about a child who was born in Galway in 2013, and his dad was an Afghan national who obtained refugee status in Ireland in 2006. Not long after the child was born, the dad was informed that there was an intention to revoke his refugee status for reasons related to fraud. And then not long after that, there was an application made for an Irish passport for the child, and that's based on the provisions that if your parent has resided in the state for 3 of the previous 4 years, you're entitled to Irish citizenship. This application was refused because the father's refugee status had been revoked. So when it comes to the Supreme Court says a change in the circumstances does not mean that that father was never a refugee, never a refugee, and that revocation could only take effect from the date of a formal decision to revoke. So in effect, it would be prospective and not retrospective. And the Supreme Court really emphasizes the importance of citizenship and derivative rights. And really the principle that arises from that is that a resident status conferred by the state on a parent based on false or misleading information could, under the terms of the relevant legislation, which is important, be included for the calculation of the period, that 3 years required to confer an entitlement of citizenship to the child. So that's a very interesting case in terms of children and citizenship and derivative rights. And the next case is A and B. So A and B is a case about international protection, and these 2 individuals had applied for international protection. Applications were refused, and the procedures kind of keep going, and the orders are made for their deportation, but they had not appealed those Section 39 recommendations within the timeline prescribed. Comes to the High Court, and the High Court says these 2 individuals do not fit within the definition of applicants, and therefore they can't apply for an extension of an appeal. And then in the Supreme Court essentially says that that assessment is too narrow and basically operates against the individuals in such a way that infringes on their right to fair procedures. So a very interesting case there, especially in terms of right to fair procedures and access to remedies. And then the last case is MK Albania. So this concerns deportation in Article 8 of the European Convention on Human Rights. So Article 8, as many of you may know, is an article that provides a right to private and family life. And it's a very important right when we consider deportation cases, not only in Ireland, but across Europe. Article 8.1 is that right to family and private life. And then Article 8.2 allows the state to interfere with that right where there's a pursuit of a legitimate aim. So there's kind of a proportionality test within Article 8.2. So the case is MK. He's a minor who arrives to Ireland on his own in 2016, lives with a foster family, goes to school, and then applies for international protection in 2017. That application is refused, and leave to remain is also refused, and a deportation order is issued. And within that decision, there's reference to a RASGAR test, and that's a test that comes out of a case in the UK, a RASGAR case. And there, the court kind of sets out 5 key questions to ask in considering whether or not someone's Article 8 rights are interfered with, and that kind of proportionality assessment. This case then comes towards to the Supreme Court, and the ultimate decision is split, but the Supreme Court unanimously agrees that the minister had erred in her approach to considering the rights of Article 8 rights of this individual, of MK. And the minister had initially said that the Article 8 wasn't even engaged because exceptional circumstances had not applied. That idea was upheld in the High Court. But instead in the Supreme Court, they said there's a very low threshold that is required in order to engage Article 8 rights, and this is seen throughout the case law of the European Court of Human Rights. And therefore, Article 8 is quite easy to engage. The next step would then be that proportionality assessment. So that's how it should apply, and that's how it should operate. But ultimately, the decision was upheld and the deportation was upheld. But this case is really important in terms of how to do that balancing act and at what stage that consideration, Article 8 rights and that proportionality test should take place. And a related case, if you want to look at it, is ASA versus the Minister for Justice and Equality, which was decided on the same day.